Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to do a verdict search where we examine cases with a specific injury in a specific jurisdiction. And what we're going to do today is at the request of one of our viewers, and she had asked us to do a complex regional pain syndrome, or CRPS, injury, and to see what this injury is worth in Texas and specifically in Dallas. So I found 13 cases in Dallas, Texas, and I'll give you a brief overview. The highest verdict was actually also the most recent. It came down on May 19th of 2025, and it was for $2.4 million. The average result was 922,000, and the lowest, according to this chart anyway, was only 5,000. So I guess that one was not proven. So let's get into it. Let's examine some of these cases and discuss it and see what the common factors are. So the first case that I'm seeing here is a plaintiff, a driver, and the driver hit a stationary vehicle, and that caused injuries. So it was a Dallas County case. The verdict was May 19th, 2025. It was a lady who was 40 years old. The incident itself was on September 27th of 2018. The plaintiff, her name was Annika. She was in her early 40s. She was a school principal. She was walking across the parking lot of an independent school district administration building, and she was walking behind a stationary Volkswagen Passat when a lady in a sport utility vehicle backed into the Volkswagen. And then what happened was the plaintiff alleged that the Volkswagen was pushed back and struck her right wrist. And so the plaintiff sued the driver who was backing up and hit that stationary Volkswagen for negligence, including backing unsafely and failing to keep a proper lookout, right? So that makes sense. And then the defense denied that the Volkswagen came into contact with Annika at all. They said there was no contact. And so the injury, she went to the emergency room the next day on her own. She said that the impact to her wrist caused complex regional pain syndrome, CRPS, in her right dominant arm and shoulder, and that she developed anxiety, depression, and post-traumatic stress disorder. So from her arm and shoulder pain, she had extensive diagnostic testing in addition to steroid injections, stellate ganglion blocks, physical therapy, cognitive behavioral therapy. She had ketamine therapy. She needed an implantation of a trial spinal cord stimulator. And the cognitive behavioral therapy provider also treated her for psychological issues that she alleged were caused by both the incident as well as the resulting pain from the incident. And so the spinal stimulator was not effective. It didn't work. It had to be removed. And at the time of trial, Annika was still undergoing physical therapy and cognitive behavioral therapy. And at trial, two upper extremity surgeons testified, including one that had been retained by the defense early in the case. And both doctors gave the opinion that the plaintiff had CRPS as a result of the incident and would require treatment for the rest of her life. So that's kind of powerful, right? Even the defense retained this expert, but the expert, didn't become an expert for the defense. And now the expert is saying, look, I have to say with a reasonable degree of medical certainty, the CRPS is because of the crash, and it's going to be permanent for the rest of her life. It's painful, lifelong, permanent. You can't really do much better than that. So that was powerful evidence. Now, the plaintiff acknowledged that she had treated for anxiety when she first became a principal as well, but that anxiety resolved several years before this incident. And then she actually was seeking 1.5 million for future medical expenses, 690,000 for loss of earning capacity, and 5 to 6 million for non-economic damages, which is all her pain and suffering, both past and future. The non-economic elements submitted to the jury were past and future physical pain, past and future mental anguish, past and future physical impairment, and past and future disfigurement. Now, the defense denied any contact between the plaintiff and any vehicle, and further, the defense argued that the anxiety was pre-existing and that the amounts she was seeking were excessive. So, typical defense argument. So the result was that the jury found that the defendant was liable for the occurrence. It determined that the plaintiff's damages totaled $2,425,507. It was broken down as follows: $800,000 for future medical costs, $30,000 for past physical impairment, $175,000 for future physical impairment, $290,000 for past physical pain, $350,000 for future physical pain, $50,000 for past mental anguish, $100,000 for future mental anguish, $630,507 for past loss of earning capacity. And so the total was $2,425,507. So yeah, the difference I'm seeing, between New York was that New York would just do like past pain and suffering, and that would include other things like loss of enjoyment of life, impairment, pain, mental anguish. It's all included in that. So I guess you just get a bigger amount. But this is interesting because Texas has actual specific things that are included in the non-economic damages. And I guess it's based on the proof that you submit. So they actually have impairment and you get money for impairment, physical pain and you get money for physical pain, mental anguish and you get money for mental anguish. I think that's actually better, because you have the more categories you have, the more money you get for each category. So the total is going to be bigger. So that's actually better for the plaintiff. So yeah, so that was the result. The offer was $250,000 during trial after the policy limit stower's demand had expired. And the way that works is, I guess, a stower's is kind of like a bad faith, I believe. So basically you tell them, hey, I'll take policy limits. And if they say, no, they're not going to give you the policy limits, well, then you say, well, now, it's open. Whatever I get, you have to pay. And so if that already expired, and then now they're saying, oh, we'll give you the policy limits, we'll give you the 250. Well, wait a minute, it's too late now. I'm coming for you, right? I'm going to get 2.4 million. Why would you take 250 at that point? You could have settled for 250 when I gave you the window of opportunity, but you let it expire. So too bad, so sad, insurance company. Now pay 10x, right? So the jury vote was 11-1. And yeah, that's about it for this case. So that's actually a very good case for the plaintiff. Now, the next case I'm seeing from 2018, and it was a pedestrian who slipped on a wet pavement. And what happened here, it was also a lady, a 50-year-old lady. It happened on September 19th, 2013. The plaintiff, her name was Josette. She was 50. She fell while walking in the parking lot of an apartment complex where her son lived. The property owner, and then, it was a company, a limited partnership, and she claimed that she fractured her right knee. So she sued the owner on the theory of premises liability. It was uneven concrete. She sued the property owner, the manager, management services, partners. I guess it's a big complex. It had like LLCs and a bunch of different entities. And so, yeah, she basically claimed that the uneven concrete was an unreasonably dangerous condition. And she also argued that the lighting in the area was inadequate. The defense argued that the uneven concrete did not pose an unreasonable risk of harm and that the lighting was sufficient or adequate. The defense also argued that it was raining heavily and that the plaintiff just slipped on the wet pavement, although the plaintiff and her son denied it was raining at the time. The defense also questioned the plaintiff's credibility based on her testimony that she lived in Mississippi and was only visiting her son at the time of the accident. The defense suggested she was actually living with him at the time, and it was undisputed that the plaintiff lived with her son after the fall. So the injury was that, her son took her to the emergency room. She was diagnosed with a comminuted fracture of the right patella. So that's going to be the right knee, the patella. And a comminuted one means that it was broken into little pieces. So it's kind of a bad fracture. And she also claimed that she eventually developed reflex sympathetic dystrophy, RSD, which is similar. That was the prior name. That's what it was called before it was called CRPS. So she stayed overnight in the hospital and underwent open reduction with internal fixation, which is a major surgery where they put in plates and screws and try to hold together the fracture. Because remember, this was a bad fracture and it was broken up into pieces. So she followed up with physical therapy, but continued to complain of knee pain. And in April of 2014, she had another surgery for the removal of the hardware. And her surgeon diagnosed her with RSD in her knee and referred her to a pain management specialist. The pain management doctor prescribed pain medication and was willing to perform steroid injections, but the plaintiff declined the injections, and she was still taking medicine for the constant knee pain at the time of trial. She sought a little less than $26,000 for past medical expenses. She also sought damages for past and future physical pain and suffering and past and future mental anguish. And, she was seeking a total of $667,780.99, which isn't like, an astronomical amount. That's pretty, fair. We settle cases with open reduction, internal fixation, sometimes for over $1 million. So to go to trial and to just say, hey, all I want is 667,000 is not, not being very greedy. Now, the defense neurology expert gave the opinion that the plaintiff did not meet the Budapest criteria for RSD. And, I've done other videos about CRPS, and I've talked about what the Budapest criteria is. So you could look at those videos. There was one where we did a CRPS trial, and we talked about the Budapest criteria. So the Budapest criteria is something that's known. It was actually like a bunch of doctors met for a conference in Budapest, Hungary. And I guess they came up with like criteria. And I think you have to make, from what I remember, you have to have 2 out of the 4. And if you do, then you can diagnose CRPS. But you don't have to. It's just like a suggestion. Some doctors can diagnose it without the Budapest criteria, which is my expert said in my case. But, the expert also gave the opinion that the surgeon based his RSD diagnosis partly on symptoms that, unknown to the surgeon, the plaintiff had experienced years before the incident. So that's what the defendant argued. And so what happened here was that the jury rendered a defense verdict. They actually said that it did not find that the plaintiff's or the defendant's negligence, if any, proximately caused the incident or the injury. So it was a 4-day trial, 4.5 hours of deliberations, 4 men, 8 women on the jury. It was a 12-0 vote. So that one did not go well for the plaintiff. Now here's another one. I don't know if I want to do, I'll just look over some of them. If I find something interesting, I'll do the full case, but I don't know if I want to do the full case for like every case because there's 13 cases. But here's another one. It was a contusion that led to complex regional pain syndrome. It was also in Dallas, a verdict for the plaintiff, but it was only $5,000. So this is a really small one. And this was actually a 45-year-old self-employed insurance agent. He was using a restroom in a Hilton in Dallas. It says he sued the owners claiming premises liability. And when he attempted to use a sanitary tissue disposal box attached to the inside of a toilet stall, the 2-pound metal box came loose from the mount. I don't know how that would hurt him, but let me see. Let me try to click through this. Came loose from the mounting and fell approximately 1.5 feet onto her foot, causing injury. Well, I don't want to say it, but this is SHITTY case. No, it's not. This isn't a good case. Because, come on, thing fell. First of all, the thing's not heavy. It fell a foot. What are the odds that's going to cause? I guess it could conceivably, but you'd have to be a really good lawyer to win this one. And, they only claimed $57,000 in expenses. The plaintiff sought an unspecified amount, but the defense disputed the damages. They claimed the impact of the falling box would not have been sufficient to cause the injury. And I guess that's not a great case. But anyway, they got $5,000 for it. It doesn't really say what the CRPS was. A contusion of the left foot resulting in complex regional pain syndrome. But the evidence of the $57,000 in medical expenses was barred at trial. So I guess they didn't have any evidence. And she just claimed that her injury caused this chronic swelling in her left foot and chronic pain. But I don't see like any testimony or proof of any doctors, nothing really here. At least it wasn't written here. So it was a 1-day trial and the jury only deliberated for 1 hour. And the demand was $250,000. The offer was only $5,000. And the jury vote was 6-0. So I guess at least they didn't get less than the offer. At least they got something. Here's another case. This one is from January of 2014. Plaintiff claimed a crush injury to the lower leg in a collision. And this one was only $20,000 result. And then another one is 0. Another one is 21,000. So it's not a great venue, I guess. Here's one for $2,139,000. This was on August 25th, 2005. Also a lady, Valerie, she was 49. She was a pharmaceutical rep, and she fell off a Bosu balance trainer device during a session with a personal trainer at Victory Gym in Cedar Hill. So what happened here was she fell off this device. She sued them because she said, well, it was positioned dome sit side down rather than using it in the manner recommended by, I guess, Fitness Quest. It was like a product's liability. So she argued that the warnings on the device were inadequate because the manufacturer was aware that trainers were misusing the device. So I guess with the Bosu, it's like flat on one side, then you have the ball. And I guess, the dome side down, maybe you're not supposed to use it that way, although a lot of people do use it that way, but I guess maybe this one wasn't supposed to be used that way. Anyway, she lost her balance and fell backwards. She landed on her wrist, fracturing both wrists. And she claimed nerve damage. And so she had the complex regional pain syndrome, and she claimed lost wages of $300,000. Past medical bills were $127,500, and a treating neurology and pain management specialist diagnosed her with CRPS, but later said she exhibited no symptoms of this condition. The defense medical expert found no symptoms. She couldn't work as a pharmaceutical representative, and she claimed future lost earning capacity of 1.6 million and sought $3,000 a month for past and future pain and suffering, past and future physical impairment, and disfigurement. So I see she just sought $3,000 a month. You can't really do that in New York. In New York, you just have to give a total amount. You can't say, you could talk about how it affects you like every second, every minute, but you can't say, hey, I want this per hour, or this per week, or this per month. But I guess in other states you can. So the result was that they reached a high-low agreement. And so the parameters were 200,000 to $1 million. And the jury found that 85% fault on the physical therapist or the trainer. And then I think the gym was 15%. I'm sorry, no, the plaintiff was 15% negligent, and found that her damages were 2.1 million. So comparative fault reduced it to 1.8, but the high-low reduced it to 1 million, right? Because that's the high. You can't get more than $1 million. But she had 200,000 on the low. So if the jury gave her 0, she'll still get 200. So that's how a high-low works. You have parameters. So anyway, so the verdict was, it doesn't really matter what the verdict was, but basically it was broken down. The big money was 1 million for future lost earning capacity, 400,000 for future pain and suffering. Those are like the big elements. 225,000 for past pain and suffering. The trial took, the demand, by the way, before was 750,000. The offer was 300,000. The trial took 11 days. The jury deliberated for 2 days. The jury vote was 11-1, and it was 7 men and 5 women. So interesting case, good result, for this kind of case. Those are tough cases because it's kind of like she's standing on a device. It's positioned dome side down, rather than using it in the manner recommended by Fitness Quest, which is the manufacturer. But I guess she just tripped off of it. But of course, if you're standing on it dome side down, you're standing on the flat part, you're gonna lose your balance. But it's hard to balance on the dome side up as well. You could fall there too. I don't know which one is. Dome side down, people usually use for push-ups and things like that. But I guess she was standing on it, and she was working with this trainer. Yeah, the trainer was found mostly at fault. Tony Hall. Okay, so that's that case. Let me see what else we have here. Here's another case from 2008 where a worker's hand was mutilated in a Skinner machine at a meat plant, but the result was 0. Another one where a teen driver hit a vehicle making a U-turn in front of her, also 0. These are all CRPS cases. A plaintiff alleged her arm was crushed in a hospital bed rail, also 0. Plaintiff claimed door was slammed on her hand at work, also 0. Jury denies nurse who fell on the job workers' comp benefits, that was 0. Defense wins battle over lifetime income benefits, that was also 0. So the rest of them are basically all 0. So I guess it doesn't sound like a very good, I guess Texans are a little conservative. They don't like to give money. If they smell anything fishy, they'll send you home with 0. Be careful with Texas. Don't mess with Texas. But, if you have a good case, or if you have a good lawyer, or if you somehow have some kind of strong evidence, you can win, but not more than about 2 million, as we saw here. So these are just basically the results in Texas. So I hope this was helpful for the lady who asked, and also for others. because CRPS is, kind of a common condition, and we're doing other cases with CRPS, so we're always learning more about it. So yeah, let us know what you think. Please like and subscribe to our channel. If you need a consultation, just text me. It's 347-566-9595. Just let me know your name, a little bit, like one sentence about what happened, your injuries or your symptoms as best as you can, the date of incident, your city, and then, we could just schedule a call. Happy to do that, and it's free and confidential, and then maybe we could help you if you need an attorney. Like here in New York, we could take the case. If it's somewhere else, we could partner with someone in, like, for example, Texas. We have some partners in Florida, California, all over the country. We even got calls for like Alaska and Hawaii, and we tried to find lawyers. I don't know if we were successful, but we worked on it. And then we have, Iowa, and we definitely had cases up in, like, I think Wyoming, and all over, basically anywhere. So yeah. Okay, everyone, have a great day and all the very best. Bye-bye.